Much, Mr. President.
Mr. President, distinguished members of the court, good afternoon. Well, Mr. President, it's always somewhat frustrating to plead in front of empty chairs, but at least electronic progress can spare us this frustration, but another will indeed replace it, because we are deprived of the solemnity of the great Hall of Justice and of its ceremony. Now, the case before you today is both of singular importance, because it is dealing with the stability of legal situations and territorial situations that is at stake, and yet very straightforward, as the facts speak for themselves. As my friends have demonstrated, it's enough to read the text of Article 4 of the Geneva Agreement of the 17th of February 1966, which is reproduced in tab 21 of your folders, and to refer to their travaux préparatoires and to their follow-on, for there not to be any doubt that you enjoy jurisdiction in the instant proceedings. I therefore can be relatively brief in recalling that the decision of the Secretary-General of the United Nations to refer the parties to the court so as to finally settle their controversy is legally binding, and that Venezuela has indeed fully consented to it being so. Having done so, I would then come back, also briefly, to the scope of the controversy, which is before you today. Mr. President, in the letter that was sent to you on the 18th of June 2018 by the President of the Bolivarian Republic of Venezuela, which you will find in your folders, has challenged the jurisdiction of the court, claiming that his country had not accepted it. To support this contention, he gives explanations which can no doubt be summarized as follows. First of all, although actually one is dealing with a treaty, the Geneva Agreement of 1966 was apparently only an arrangement by which Guyana and Venezuela only committed themselves to seek a friendly solution. And secondly, the decision of the Secretary-General of the United Nations of the 30th of January 2018 would only represent a recommendation made to the parties to refer the case to the ICJ, and therefore this would be a recommendation shorn of any binding force. Therefore, absent any consent from the side of Venezuela, the court would not enjoy jurisdiction so as to entertain the application that was filed before it by Guyana on the 29th of March 2018. Now, this explanation, which is somewhat confused, has been echoed in the memorandum which the respondent sent to the registrar on the 28th of November 2019. And let us also quote from the conclusion: even if the submission of this dispute to a court or tribunal were to be seen to be possible under the Geneva Agreement, it would mean in any case that there was a need to settle the dispute in accordance with the Geneva Agreement, to specify the subject matter of the dispute and the parameters to be taken into account beyond mere international law rules. This would require the conclusion of a special agreement. Now, I don't think it's very useful to dwell on the principle of state consent to the jurisdiction of the court. Guyana indeed does not challenge this at all. And it is enough to note that the consent of both parties arises due to the implementation of the provisions of Article 4, Paragraph 2 of the 1966 Agreement, which Venezuela has not challenged as being legally binding. It results from this provision that in the absence of a settlement of the controversy via a means chosen by the parties or by an appropriate international organ, the Secretary-General was entrusted by the parties to select, to choose, not to propose or to suggest, another of the means listed under Article 33 of the Charter of the United Nations. This provides a firm commitment on the part of the parties to accept this choice. The Secretary-General has chosen. This decision is binding on Venezuela and represents, in the instant case, the basis of your jurisdiction. Mr. President, Article 4, Paragraph 2 of the 1966 agreement, without any doubt, represents a conditional commitment taken by the parties, conditional maybe, but nonetheless a commitment taken by the parties to accept the jurisdiction of the court. And we can just read it briefly. The first lengthy sentence of this provision is not controversial. Venezuela does not challenge the fact that the two states have not reached an agreement on the choice of a means of settlement any more than it claims that the parties have agreed to an appropriate international body apart from the Secretary-General of the United Nations. It's also not challenged that the Secretary-General has offered a good offices process to the parties, and then by strengthening the powers of his representative to carry out mediation. Now, whatever the case, this first attempt at settlement has failed, as Philip Sand has just demonstrated a few moments ago. Pursuant to the clear text of Article 4, Paragraph 2, it belonged to the Secretary-General to select or choose one of the other means listed or stipulated in Article 33 of the Charter of the United Nations. Now, Venezuela has admitted that the 1966 agreement is a legally binding accord validly deposited at the United Nations, which unequivocally regulates the territorial dispute between Guyana and Venezuela. End of quote. However, it seems to feel, as a respondent, that all the means stipulated in Article 33 of the Charter have to be successively exhausted in the order of their listing, as we have already heard. But this interpretation is not tenable, as Paul Reichler has already indicated. There's therefore no need to repeat his statements. And Mr. President, Article 4 would make no sense at all if the parties were able to reject the choice carried out by the Secretary-General of the United Nations. This interpretation, which is derived from the very text of the provision, is in line with both the aim and object of the 1966 agreement and the context which surrounds that of Article 4. The first paragraph also foresees that at an earlier date the two governments without delay should choose one of the means of peaceful settlement provided in Article 33 of the Charter of the United Nations. One of the means. So in other words, this was already a choice, a free choice, but a common choice, which could be independently select one or and only one of the means of settlement mentioned in the Charter. Now, so as to reach this result, it would be absurd to exclude recourse to arbitration or to judicial settlement, which are certainly the most certain and sure means of ensuring a final solution to this controversy. And the fact that in the Protocol of 1970 the two parties have agreed to suspend this timetable does not change anything about the interpretation to be given to the 1966 treaty. The 1966 treaty was designed to end up with a final resolution of the controversy. The Protocol simply suspended its application. This is clearly without bearing, as is clearly explained in Article 3, which you'll find in tab 21 of your folders, according to which, on this date, when the Protocol ceases to be in force, the function of Article 4 of the Geneva Agreement shall be resumed at the point at which it has been suspended. End of quote. Venezuela, furthermore, specifically recalled this in 1981 when they communicated their intention not to renew the protocol, and I quote them in English. the immediate consequence of the termination of the Protocol of Port of Spain is the full reactivation of the procedures indicated in the Geneva Agreement from 1966. End of quote. So whilst it hasn't challenged that the 1966 agreement is binding, the respondent, Venezuela, has claimed that the letters sent by the Secretary-General of the United Nations to the heads of state of both parties, dated the 30th of January 2018, do not represent a decision. And President Maduro has claimed in his letter of the 18th of June 2018, which I quoted a few moments ago, that the only obligation binding on both parties is that of reaching a practical and mutually satisfying agreement through friendly negotiations. Now, this kind of analysis defies both the text and the context of the letters of the 30th of January 2018 and amounts to emptying of all substance both the decision of or the agreement of 1966 and the decision of the Secretary-General of that same year, 2018. Now, I note the flagrant contradiction which exists between this claim, echoed in the memorandum, and which is incompatible with the text of these instruments, and another claim also contained in the letter of the head of state of Venezuela, as in the memorandum, according to which, and I quote, "The only object, purpose, and legal effect of the decision of the 30th of January 2018 of the Secretary-General of the United Nations Secretary-General in accordance to paragraph 2, article 4 of the Geneva Accord is to choose a specific means for the friendly resolution of the controversy." And this is exactly what the Secretary-General has done. The requirement for a new agreement between the parties to refer this controversy to the court would have had as its effect simply making this referral subject to the discretion of one of the parties, who could therefore indefinitely postpone the settlement of the controversy, which is, after all, the ultimate aim of the 1966 agreement. Now, this begging of the question further overlooks an important contextual element, which is that under paragraph 1 of Article 4, it is provided that the two governments shall without delay choose a means for peaceful settlement provided in Article 33, and that they should choose one of these means, according to the beginning of paragraph 2. They are then invited to reach agreement on and accept any choice of an appropriate international body in this case. In any case, it now falls to the parties to choose by agreement one of the means of settlement and to agree on this point. But this does not at all apply if they fail to agree. In this case, the two bodies will turn to the Secretary-General of the United Nations, and it's even clearer in English, they shall refer the decision to the Secretary-General. So up until then, the agreement between the parties has been sought. But if one of these means does not lead to a solution of the controversy, the Secretary-General of the United Nations shall choose another of the means stipulated in Article 33. Here, as a contrast, it's no longer a question of the agreement of the parties. The Secretary-General should choose and choose alone. The meaning of the words is perfectly clear, as indeed is very clear from the context. To choose is to decide. Still coming back to his letter of the 18th of June 2018, the President of the Bolivarian Republic of Venezuela has stressed that his country has never accepted the jurisdiction of this honourable international court due to its historical tradition and fundamental institutions, end of quote.